Good afternoon, everyone. This is Tenant Talk Live with the National Low Income Housing Coalition. My name is Kyle Arbuckle, and I'm a housing advocacy organizer at the coalition. We'll give it a few minutes to let more people join. And as you join, we ask that you tell us where you're from and your name so we can get a sense of where our listeners are. So you can do that in the chat at the bottom of the screen. So yeah, we'll give it a few more minutes. All right, so we have Morgan from Las Vegas and Judy from the Legal Aid Society of San Diego. As I mentioned before, if everyone wants to put where they're from in the chat below so we can get a sense of where everyone's from, that'd be great. You can do it in the chat at the bottom of your screen. And we'll give it about 1 more minute or so. So we have Renua from Memphis, we have Abby from DC, we have Michael Kane from Nat. Hi, Michael. We have AJ Jelks from Wisconsin, Sharon Sherman from the Greater Syracuse Tenants Network. Hi, Sharon. We have Mark Esco from Fort Lauderdale. We have Aaron Shaw in Polk County. John Matthews from Long Beach, California, the Justice Collaborative. All right, so I think we'll get started. We have a special guest tonight, Eric Dunn from the National Housing Law Project. He's the Director of Litigation, and he has been making the rounds on the Zoom circuit, talking about the CDC eviction moratorium that probably affects a lot of people in your communities or may affect you yourself. So he's gonna give us a presentation on what this moratorium looks like, what it does, and how it can affect you, and then we'll be able to ask some questions afterwards. So Eric, like we said, if you want to share your screen, that's fine. You have the floor. Eric, I think you're still muted.
Just thinking about the slides and not my microphone.
Yeah.
Can everybody see the slides?
Yeah, I can. Yep.
Okay. You still see them?
Yep.
Okay, great. All right, so on September 1st, the CDC announced that it was imposing a nationwide eviction moratorium that was formally published in the Federal Register on September 4th, and that's when it went into effect. But what does it do? Well, in summary, the CDC's moratorium is designed to protect the public health, designed to prevent the spread of COVID-19 through, the mass evictions that we were facing heading into September. Some estimates had put it as high as 40 million people could be evicted, over 20 million households. That's nearly half of the renter households in the country, more than 10% of the US population. So having that many people displaced from their homes, really over the course of about 10 or 12 weeks, certainly would have led to a large increase in the spread of COVID-19. So the rationale for the moratorium is that by preventing evictions, we can at least, slow down the spread of COVID-19. The CDC's order prohibits any landlord, which also includes an owner or other person with a legal right to pursue eviction or possessory lawsuit. So that would be a property manager or someone else who has the right under usually state law to bring the case. Prohibits that person from evicting any covered person. And what a covered person is kind of complicated. So we'll go over that in in more depth in a minute. But that's basically a tenant who's able to provide a declaration establishing that they meet the criteria for protection under the moratorium. So it prohibits a landlord from evicting any covered person from a residential property where the order applies, and it lasts until December 31st of 2020. So as I mentioned, in order to invoke the protection of the moratorium, a tenant needs to be able to provide a declaration to the landlord. Once the landlord receives that declaration, they're prohibited from taking any action to remove or cause the removal of a covered person through the end of the year. But if the tenant does not provide the declaration, the CDC's order doesn't have any effect. So who qualifies for the protection? Who can be a covered person? It's any tenant living at a rental property who provides the declaration. And the key is to be able to provide this declaration, you have to be able to truthfully make 5 basic statements. The first one is the tenant has to be able to say that they've used best efforts to obtain all available government assistance for rent or housing. Now, I think one concern about this provision is that people may be living in communities where in the past there may have been some type of rental assistance program or some government funds available to help with rent arrearages, and maybe the person didn't apply for it, didn't find out about it in time. Then they may feel like, well, I didn't use best efforts, I can't sign this declaration. The way we interpret this is the tenant just needs to use best efforts at some point before they sign the declaration. So even if you didn't use best efforts yesterday, find out about the CDC moratorium today, you go and use best efforts now, apply for whatever might still be available, and then you can sign the declaration. That's only the first of the 5 criteria. Secondly, there's an income limit. So it's pretty high. It's up to $99,000 of expected income in 2020. And if it's a married couple filing jointly, it can be up to $198,000 between the 2 of them. Or you can also qualify if you received one of the stimulus checks earlier during the pandemic period. Or a third possibility is if you made so little income in 2019 that you didn't have to report income to the IRS. So it doesn't have to be all 3 of these, just any one of these 3 criteria, and a person can meet the income limit. The third requirement is that a person needs to be able to say truthfully that either they had a substantial loss of household income, or that they're experiencing extraordinary out-of-pocket medical expenses, and for that reason they're not able to pay their full rent. So kind of multiple components there. One, not being able to pay your full rent is one requirement. Of course, if you are paying full rent, then you probably don't need the CDC moratorium. But if, let's say you're in a situation where maybe you fell behind in rent a couple months ago because you lost your job, you've since gotten back to work, got a new job, and now you can pay full rent again. If you still can't catch that arrearage up, you can credibly say that you're not paying full rent because you're not paying full rent under the lease. But secondly, it has to be, the reason that you're not paying full rent either has to be due to a substantial loss of household income or extraordinary medical expenses. Importantly, it does not require that you show a connection between the loss of household income and COVID-19. Fortunately, I think a lot of people have kind of read that requirement in, but it doesn't exist. So it can be a loss of household income for any reason. Secondly, it's a loss of household income. So anyone in your household loses the income. So you're sharing rent with a roommate, your roommate loses his job, you still have your job, but you have a loss of household income. So both of you can credibly make that statement. Extraordinary medical expenses, the order defines as costing more than 7.5% of the tenant's gross income for the year. So there's a specific calculation you can make to see if you qualify for that. Again, there's no requirement of showing that any of this is directly or even indirectly related to COVID-19. There's no requirement of providing any kind of corroborating documentation or anything like that. You just have to be able to say that you've had a substantial loss of income or extraordinary medical expenses, and for that reason, not able to pay full rent owed to the landlord. The fourth criterion is the tenant needs to be able to make some kind of partial payment to the landlord. And it's the tenant's best efforts to pay as much of the rent as they can based on their personal circumstances. Now, unfortunately, there's been quite a bit of chatter about landlords thinking that they may be able to challenge tenants who make partial payments and argue that the tenant could have paid more. In our opinion, that's not proper, and courts should reject that. We'll have to see what the courts ultimately do. We definitely think that if the tenant makes a good faith calculation of how much they can afford and they tender that, they should be okay. I think where tenants might get into trouble realistically is if they either don't make partial payments at all, or they make such minimal payments that the landlord might be able to show that the tenant didn't really make a good faith attempt to pay what they could. The fifth and final criterion is that the tenant must be able to truthfully say that if they were evicted, they would either become homeless, or likely become homeless, or they would be forced to live in close quarters in shared housing. So these terms are kind of ambiguous: likely to become homeless, forced to live in close quarters in shared housing. I think, in my opinion, where you might draw the line in something like this would be maybe you had a college student who could move back in with parents or something and not be living in a crowded environment. That, that might be an alternative housing option available to somebody that would prevent them from being able to sign this. But I think it's really directed at people that would either be moving into shelters, that would, certainly people that would be sleeping outdoors or living in cars, things like that. People who would be doubling up with other households. All those forms of homelessness or housing instability should be covered. So, of course, we've already seen that there's quite a few complications with this moratorium, but there's even more questions that tend to come up, showing really how complicated this can be. So I'm just going to go over some of the more common questions that people have raised. First, I mentioned it, the CDC order only applies in certain jurisdictions. This is really tricky. The order, first of all, in order for it to apply, the jurisdiction has to have reported confirmed cases of COVID-19. So everywhere in every US state and every US territory has confirmed COVID-19 cases at this point, except for one, and that's American Samoa. And so for that reason, the CDC order does not apply currently in American Samoa. Now, if American Samoa reports a COVID-19 case, then at that point, the order would take effect there. But as of now, it does not apply in American Samoa. Secondly, the order provides that it's not applicable in states or other jurisdictions that already have their own moratorium that provides equal or greater public health protection than the CDC order does. Now, there's a handful of states that have their own eviction moratoria. So how do you figure out which one provides a greater public health protection? After analyzing this, the conclusion that we've come to is that the way this will most likely be interpreted is that the CDC order provides kind of a baseline level of eviction protection. But if the state moratorium reaches a situation that the CDC order does not, then the state order would provide eviction protection in that scenario. One of the reasons we feel this way is because the whole order talks about how we're stopping evictions to stop the spread of COVID-19. So the only logical interpretation of public health protection from the order is that it means stopping evictions. Secondly, that the only other way that we could think to interpret this would be you might have the CDC or possibly some other entity that would basically make an analysis and compare the state moratorium to the CDC order and figure out which one provided greater protection and say that's the one that applies. But the CDC hasn't done that. It would take a long time and probably not commensurate with the 4-month duration of this order. So it's just not clear how that could possibly happen. So we don't think that would be a logical interpretation. So basically, we think people can confidently look at the CDC order as providing a minimum level of protection against eviction for people everywhere except American Samoa. And then anything that the state provides over on top of that would also be in effect. So the order from the CDC does not provide any kind of time limit or deadline to provide the declaration. So, you don't have to provide it within so many days or weeks or anything like that. One sort of practical consideration, however, is that the way the order works is by prohibiting the landlord from taking actions to remove the tenant. So if the landlord's already taken all the actions the landlord needs to take, then the order may not protect you at that point. So we don't think that you can use the order to get back into a property if you've already been evicted, because obviously there the landlord doesn't have anything further to do to remove you. But we do think that the declaration can be given after an eviction notice has been served, after a case has been filed, probably even after the court has even entered a judgment giving a landlord possession of the property, because they still have to take steps to get the sheriff to come out and do a physical eviction. So certainly the sooner the tenant provides the declaration to the landlord, the better. But as long as the tenant provides that declaration to the landlord at some point before they're physically evicted, we think that the order should protect them. Now the order came with an attached declaration form that tenants can use to provide the declaration. We have a link to that form on our website, nhlp.org. But you could probably find that form or another version of it just by Googling CDC moratorium. The CDC order specifically states that you're not required to use their form. You can use the term similar declaration. But I think people should be very careful about changing the actual words of what the declaration says, because there's a risk that a court might find that what you provided was not similar enough to the CDC's form. So the safest thing for tenants is if you can sign the actual form the CDC provides, then that's not going to be an issue. But I think as long as really you're just changing maybe the formatting or the font or things like that, that really shouldn't raise any questions either. But I think if people start changing the text, that raises some risks that a landlord may not honor it, and then a court may not require a landlord to honor it. The CDC does not specify whether the declaration can be provided in electronic form, whether you have to actually print out a paper copy and sign it with a pen, or if you can sign it online somehow, if you can email it, if you have to deliver a paper copy. What we think the rules will be is that if state law has authorized people to transmit things electronically, sign things electronically, that should also hold true for this document. I do think if people are able to provide a paper copy to a landlord signed with a pen, that's probably the safest thing to do. But it's probably not necessary, especially in jurisdictions that have authorized electronic signatures. Some people have asked, should I provide any kind of corroborating documentation to show that I've lost income, or to show that I've applied for rental relief funds, or those sorts of things? We don't recommend that because we think it just creates more things for a landlord to look at and scrutinize and argue that maybe you could be making greater partial payments and so forth. So we don't recommend that. the CDC order doesn't require anything of that nature, just the declaration. In terms of how to actually deliver the declaration to the landlord, the safest thing for tenants would be to provide the declaration in a way that you can actually document or prove that the landlord received it. So, certainly if you hand deliver a document to the landlord and have the landlord sign an acknowledgement of some kind or make some record that it was received, that's a great way to do it. Sending it by email and having the landlord confirm receipt, or sending it by fax and getting a confirmation is another option. If you're not able to confirm the delivery to the landlord, it's helpful to keep a copy yourself and make your own record of when you delivered it. If the landlord were to disregard the declaration and bring some kind of eviction case against you, you can always show up to court and provide the declaration then, and it's just as effective. So this may not be hugely important, but again, the better you can document what you've done, the more likely this is going to work for you. Now, the CDC order is really not written to cover all evictions. There are 5 enumerated exceptions for evictions that can still take place, even if the tenant provides a declaration to the landlord. And these are all 5 are listed here. They all involve some kind of misconduct or lease violation by the tenant. So whether it's a serious violation such as criminal activity or causing physical damage to the premises, or the 5th one is violating basically some term of your lease other than non-payment of rent or charges. Unfortunately, a lot of cases that involve lease violations could potentially fall through the cracks. But probably the most common question we get around this is whether a tenant can be evicted simply because their lease has expired. So even if they haven't violated their lease or violated the rules or terms, if the landlord can just evict them on the grounds that their tenant's expired or for no cause. We think the answer is no. It's pretty complicated, the reasons why, but basically, one reason is that when you have a list, we have a statute that provides a list of things, and you can argue that something that's not included in that list is also authorized. That additional thing needs to be similar to the things that are listed. And since all 5 of the listed grounds require a lease violation, we don't think just a mere expiration of a lease where there's no violation is similar to those 5 and should be excluded. Also, it's just contrary to the spirit of the order. We're trying to protect public health. We're trying to minimize evictions to prevent the spread of COVID-19, allowing landlords just to evict people without cause when their lease runs out is not consistent with the intent of this protection. Furthermore, in a lot of situations where the landlord would be terminating somebody's lease without a stated reason, it's probably because the person fell behind in rent, or the landlord expects that they may have trouble paying in the future. So, because the order clearly applies to non-payment situations, we think if the eviction is motivated by the fact that the tenant has fallen behind in rent or had some trouble paying in the past, or the landlord perceives that the tenant may have trouble paying in the future, that too should be considered a non-payment scenario and covered. Once again, the order is not crystal clear on these things, and so it may be up to courts to decide how this is actually going to work. But we don't think that the mere expiration of a lease or a no-cause eviction notice should be effective to terminate a tenancy. An interesting question has arisen around whether landlords can still serve eviction notices. As I mentioned, the CDC order prohibits a landlord from taking any action to remove or cause the removal of a tenant, but it only goes through December 31st. So I think there's an unclear question as to whether a landlord could give a tenant an eviction notice as long as the date to move out is after December 31st. Now that may not seem, it may seem like kind of an academic question today because we're still in the middle of September. But I think that'll be a more significant question a couple months from now, when, if a landlord's giving a tenant a notice to move out on January 1st, and that might only be a few weeks away. So as we get closer and closer to the end, I think that's going to start to be more and more of an issue. And it's really not clear. Recently we had the CARES Act moratorium, which specifically required a 30-day notice to be given to a tenant before they could be evicted, even after the moratorium period expired. And you were specifically not allowed to give that notice during the moratorium period itself. The CDC order doesn't have anything like that. And so I think this is a real open question. We've gotten a lot of questions about roommate situations. These get very difficult to analyze, and they really kind of depend on the specific factors. But the CDC order kind of confusingly says that each adult in the household should sign their own declaration. It doesn't say they must, it says they should. And so, especially in some of these roommate scenarios, you may have maybe some of the roommates are not going to become homeless if they get evicted, and others would, and so they can't all sign. What happens? Once again, the order is not, is far from clear on exactly how that works out. But our analysis leads us to believe that as long as one person in the household signs and provides a declaration to the landlord, that should protect the entire household from eviction. Since it wouldn't really make sense to allow the landlord to evict some of the tenants and not others, the landlord's still not getting the property back. And the whole reason that the landlord would have to do an eviction would be the idea that they could maybe find someone else to move in who could pay rent. So, or pay full rent, I should say. So that sort of scenario wouldn't accomplish anything, wouldn't really make any sense. And again, the order does not require everybody to sign a declaration. It says that everybody should, not must. And we kind of interpret that as being designed so that you don't have maybe one person swearing to the truth and accuracy of all the statements in the declaration as to people besides themselves. Because one tenant may not know whether a roommate or someone else living in the premises is going to become homeless or not. So, so again, this isn't clear from the order. Courts potentially could interpret this and maybe reach different decisions, but our analysis leads us to believe that only one declaration is needed per household. Last, does the CDC order protect against landlords resorting to what lawyers call self-help, or basically taking it into their own hands, doing lockouts, cutting off utility service, using threats or intimidation to drive people out of the property, denying necessary repairs, or even actively, tampering with the premises, those sorts of things. Again, the order applies to any action taken to remove or cause the removal of a tenant. So we think that absolutely covers actions that the landlord might take themselves. And we think those are situations where the criminal penalties that the order applies would be particularly important. The criminal penalties are severe. They start at $100,000. If somebody actually were to get COVID-19 and pass away because of this, the penalties are even more severe than that. And in addition to the fines, jail time is also authorized. So last, just to talk briefly about some of the legal challenges that this CDC order is coming under. There's kind of two groups. One is, you may have heard that some of the courts have been a little resistant to complying with the order, which is unfortunate, but it's happening and it needs to be dealt with. As I mentioned, a lot of the text of the order can be a little bit ambiguous. And so some courts have reached some just genuinely different interpretations of what they're allowed to do. Some courts, for instance, are still allowing eviction cases to be filed And then the court will decide whether the case falls into one of the exempted categories and can proceed, or if not, the case may be dismissed or it may be stayed. But there are other courts that have even said they'll allow the cases to proceed, and they'll have a hearing and a trial, and they even enter a judgment against the tenant. They just won't actually do the physical eviction, or they won't enter the writ of restitution, which is the order that goes to the sheriff, telling the sheriff to physically remove the tenant. And we feel like those sorts of interpretations are really inconsistent with what the order provides. So I'd expect to see some legal challenges against those courts that are interpreting it that way to try to stop courts from proceeding with eviction hearings, because that basically allows landlords to prosecute eviction cases, which would be taking an action prohibited by the CDC order. Another big question surrounds some landlords wanting to basically challenge the accuracy of the tenant's declaration. So if the tenant decides that they can pay 50% of the rent and the landlord thinks you can pay 75%, landlords deciding that they should have some kind of evidentiary hearing where the court can take testimony and decide whether the tenant made a big enough partial payment, with the idea that if the tenant didn't pay enough, that the court could still evict the person. We really find that interpretation is completely at odds with what the CDC is trying to accomplish. And it's been our position that only if the tenant makes some kind of fraudulent or bad faith statement, so not just that they're wrong, but that they knew they were wrong, they lied in the declaration in bad faith, only then could the landlord possibly challenge it. And even then, the landlord would need to have some proof that that's what the tenant had done, not just that they just get a hearing just because they say they don't agree. But that, again, I think will be something that courts are going to have to grapple with. Then there's been one lawsuit filed in a federal court challenging the CDC's authority to enter the order. The case was actually filed by a landlord based in Virginia, but it was filed in Atlanta. And the landlord claims that basically that his tenant hasn't paid rent, and so he wants to evict the tenant, but he can't because of the CDC order, and that the CDC didn't have authority to do this. And so he wants the federal court to basically enjoin the order from taking effect. And he's made a number of arguments in his complaint, but can kind of break them down into just a couple of categories. The first one, he's expressed this in several different ways, but basically a claim that that the CDC's order violates a constitutional right to free speech or access to court, or right to petition the government for redress of grievances. Basically this idea that the only way to lawfully evict a tenant in Virginia is to take him to court, and if I can't go to court, then you're preventing me from evicting a tenant, and that somehow violates my First Amendment rights. Now, there was a case a long time ago called Bodhi versus Connecticut, which dealt with a divorce, and a person in that case wanted to get a divorce. The only way to get a divorce is to go to court and have a court declare that you're divorced. But the person couldn't afford to pay the filing fee to go to court, and so argued that the filing fee was interfering with the fundamental right to get a divorce. And in that case, the Supreme Court, the US Supreme Court, held that, yeah, that's an unconstitutional restriction on court access because you have a fundamental right to change your marital status. But has not been recognized any fundamental right to evict a tenant. So courts so far have been rejecting these types of claims. There have been a number of cases filed challenging state laws or state moratoria preventing evictions, all raising the same type of claim, and courts have been rejecting it, saying, no, there's not a fundamental right to go to court here. you're not trying to get a divorce, you're trying to evict somebody, and that's not a fundamental right. So I would expect that that claim will not succeed. There's another claim that has kind of two parts. And the basic idea is the landlord is arguing that the CDC doesn't have the authority, that Congress didn't give the CDC the power to create an eviction moratorium. And then the sort of corollary to that argument is that if Congress did give the CDC that power, well, then that was just too much. Congress improperly delegated its power to make laws to the CDC. You can't do that. Well, the thing about this argument is this is a new argument that hasn't been made in any of the previous cases dealing with eviction moratorium, because of course all the previous cases dealt with state agencies and state legislatures and governors and courts, and not with a federal agency. So this is a new and different argument that hasn't already been rejected. But if we look at the actual authority that the CDC has to impose an eviction moratorium, it comes from a statute and then a regulation implementing that statute. And what it says is that whenever the director of the Centers for Disease Control determines that the measures taken by state or local health authorities are insufficient to prevent the spread of a communicable disease, then the CDC director may take such measures to prevent the spread of the disease as he or she deems reasonably necessary. So that's a pretty broad power. It seems that Congress has given the CDC to take whatever measures the CDC finds are necessary to prevent the spread of COVID-19. Now it does provide a list here of types of things that the director can do, including inspection, fumigation, disinfection, etc. As we talked about before, whenever you have a list of different things, there's an argument that if you're trying to do something that's not on the list, it's got to be similar. So is stopping evictions similar to, sanitation or pest extermination or things like that? Not sure. But it does seem like the CDC, really needs authority to act quickly and take whatever measures are necessary to protect public health, because not all disease outbreaks are, kind of slow moving type things. You can have, very highly infectious, very deadly diseases. And if you have a government agency that needs to sit around and, have committee hearings on what they're going to do, then, maybe too late. So seems like there is pretty strong authority for, to argue that the CDC did have this power. And furthermore, that the Congress didn't just let the CDC create whatever kind of laws it wanted, that there's some pretty tight limits here. It only applies when there's a communicable disease outbreak. It only applies when state and local officials haven't taken adequate steps. And then it only gives the CDC the power to take measures to control the disease, not to do whatever they want. So it looks to me like the CDC order is on pretty solid legal ground, but litigation is inherently unpredictable. And so, we'll have to see how it turns out. The last thing I'll say about that case is that what the landlord challenging the CDC order really wants the court to do is enter what's called a preliminary injunction, stop that order from being in effect while the court weighs the legal arguments here. Generally, in order to get that kind of an injunction, a preliminary injunction, relief before the court has decided the case on the merits, you need to be able to show something that's called an irreparable harm, some kind of injury that you can't be compensated for with money, something that goes beyond monetary losses. And the landlord's basically complaining that he's not getting his rent, which is basically money. So apart from the massive real public health justification and the need for this relief that might outweigh the landlord's grounds anyway, there's a real concern about whether the landlord would even be able to show a non-economic injury, which he would need to do to get relief. So there's good reasons to think that the landlord's challenge to the CDC moratorium will be rejected. But of course, there could be other ones filed, so we'll have to see how these go. My last slide, as I'm sure you've probably heard by now or come to this conclusion on your own, even assuming the CDC order is upheld and that's properly adhered to throughout the country, if we don't have a substantial rent assistance package from Congress by the end of the year, then we'll probably be right back in the situation we were heading into September, with tens of millions of evictions looming, and possibly up to 40 million people facing displacement. So it's really essential that that this not be the only measure here, that Congress follow up with rent relief funds. And really the impact is not being uniformly felt throughout the country. It's really being centered in neighborhoods and communities of color who already face the highest rates of evictions prior to COVID-19, who are facing the highest impacts of the disease itself, and now potentially face the highest rates of displacement and eviction, because of the disease and the related economic effects. So, if we don't have a rent relief package to help with that, then I think we're looking at just really devastating fair housing outcomes, in addition to just the personal and individual impact. And while Congress needs to act, there's still plenty that state and local governments can and should do to mitigate both the short and long-term impacts of this problem. One is, as we've seen, there's a lot of cases that can fall through the cracks, tenants that may not be covered by the CDC moratorium, so state and local governments have a role to fill in those gaps and try to reduce evictions as much as possible to make sure that people don't fall through the cracks. Secondly, for people that are, they've maybe fallen behind in rent due to a job loss, due to an income loss in the past, they get back to work, their income's restored, they can pay the rent going forward. Even if they owe a big rent arrearage, we don't see that it makes sense to evict those people. I mean, if they're evicted and replaced, the new tenant coming in is not going to be paying that rent arrearage either. So state and local governments should really try to stabilize communities, stabilize neighborhoods, stabilize households by prohibiting evictions of people just based on rent arrearages alone when they're paying the current rent. That seems like a really common sense approach that state and local governments can do. That's one of the things California has done. And then for people that are facing eviction, maybe they're not back to work, maybe rental relief funds have not materialized. It's important that when jurisdictions are proceeding with evictions, that people have legal representation available, because we've seen how complicated the CDC order is. A lot of the state moratoria are no less complicated. It's difficult for people to navigate these different types of issues and protections when they don't have legal assistance. During this crisis, there are going to be millions of people that acquire landlord-tenant debts, that acquire records of eviction case filings, that acquire records of eviction judgments, that have their credit damaged. And this should not be something that follows people and limits their housing access long into the future. So jurisdictions can pass protections to prohibit tenant screening policies from denying people admission to housing in the future based on landlord-tenant debts they acquired during the COVID-19 emergency, based on eviction records they picked up during the COVID-19 emergency, and so forth. Prior to COVID-19, having a landlord-tenant debt, having an eviction record, those would almost always be fatal to a rental application, especially if there was a judgment entered against the tenant. And if somebody got evicted during COVID-19, a couple years later, the pandemic is over, they're back to work, they're stable again. This is not something that predicts what kind of a tenant they're going to be in the future. It doesn't make any sense that the people, would be denied housing opportunities because of something like this. So that's one thing that can prevent sort of the one-time eviction from just reproducing, these sort of long-term problems, long-term barriers to housing stability and success. So I think that's the end of my slides. So I think I'll stop the share and happy to answer any questions.
Thanks, Eric. That was great. Really appreciate it. A couple already. I'm sure more will come in. If everyone wants to use the Q&A box at the bottom of the screen to ask questions, feel free. So we have one from Lynn Soderstrom. Who is going to police all these criterions? Landlords, public health departments? Is there a written template? I shared our document that NLIHC and NHLP made together that has a form at the end of it. And Kim also shared the document that the CDC has. But if you want to answer the first part of that question about enforcement.
So I'm not fully sure I understand whether the question's asking the criterion for the tenant to comply with, or for sort of making sure landlords are complying with the order. But the way that we interpret the order, I mean, there's a CDC approved form. There have actually been a number of private entities that have created apps and generators you can use to populate a form. A lot of legal aid programs have forms available. It's been translated into a number of languages already. But basically there's a form, and if the tenant can truthfully make all the statements required on the form, then they can avail themselves of the protection. They provide that declaration to the landlord, and then it's the landlord's obligation to comply with it. If the landlord doesn't comply with it, then the landlord is potentially subject to the criminal penalties that the order provides for. And if the way that the landlord fails to comply is by pursuing an eviction case, then the court should dismiss that lawsuit. Now for the tenant, if the tenant, the declaration form makes very clear that this is an affidavit somebody's signing under penalty of perjury, and if the tenant doesn't believe all the contents are true in good faith and signs it anyway, then they are potentially subject to prosecution for perjury. So people should not be signing these declarations if they don't have a good faith belief that everything they're signing is true. And if people have concerns about what the language means, or can I sign, that's a perfect example of where it's critical that people have access to legal assistance.
So you would recommend people just getting in contact with legal assistance in addition to, if they're facing.
Yeah, absolutely. I mean, if the process works the way it's supposed to work, and the tenant reads and understands everything in the declaration and signs it and provides to the landlord, and the landlord says, okay, I got your declaration, you're good until January, and then we'll talk about it then. The person may feel that they don't need legal assistance, and that's fine. But if you have questions about what the language means, can I sign this? If the landlord's telling you that they don't care if you sign some paper, they're not going to abide by it. Certainly if the landlord's still providing eviction notices or starting an eviction case, then yeah, absolutely people should be seeking assistance.
So Abby asked a similar question. I think the first part of it. She has third part of her question where she wanted to know if there are any arguments that can be made that other lease violations don't pose a threat to the community should be put on hold. I'm wondering if you've come across that at all.
Well, the order expressly authorizes eviction for lease violations other than non-payment of rent or charges. However, in most in most states, if a tenant commits what's considered an ordinary lease violation, so it's not some serious criminal activity or something. It's, you put up a DirecTV satellite dish and, you didn't get permission from the landlord, or, something relatively, mundane. Most state landlord tenant acts provide for a right to cure that type of violation before you can be evicted. So instead of just giving you a notice to move out, the landlord has to give you 10 days or 15 days or 20 days or however many it is under state law to correct whatever the lease violation is. And if you do that, then your tenancy is preserved. My hope is that, people that do commit sort of ordinary lease violations, would be able to avail themselves of those kinds of protections. Unfortunately, I think there are a few jurisdictions where there is no right to cure. The landlord may have the option of giving you so many days to cure, or just giving you some other type of notice. But unfortunately, the CDC order itself doesn't protect against that.
Michael Kane from NAT asked, are undocumented people covered by the moratorium?
That's a good question. I'm glad that was brought up, because I probably should have included that in my presentation. There are no requirements whatsoever under the CDC order for anybody to have U.S. citizenship, to have any kind of immigration status, to disclose what their status is or their lack of anything. It's completely irrelevant under the order. So absolutely, undocumented people are just as entitled to protection as anyone else.
Okay. I think this is another good question that you might have mentioned, but Morgan Shaw asked, well, she said that she just wanted to flag that in Nevada, people living in extended stay, weekly motels are considered tenants and can be covered under the CDC order. So, real quick, if you wanted to talk about hotels.
Yeah, actually, that's another thing I should have included. Even though the CDC order sort of states in one part that it applies to all residential property, it specifically exempts from its definition of residential property hotels, motels, and it's like seasonal lodging. So I think it means like vacation rentals or things like that. And then it says that that's as defined by state law. So certainly in a lot of situations, people may be living kind of long-term at a hotel or motel. They may or may not have some kind of monthly lease or something. And then state laws differ in terms of how those people are regarded. Are they residential tenants? Are they transient guests? Are they something else? So really important to, if you're living in one of those situations, to contact, legal assistance in your state to figure out, how this might apply to you. Because the order exempts motels and hotels, but just because something's called a hotel, for instance, doesn't necessarily, mean you're out of luck. Under state law, you could have a tenancy, for instance.
Michael Kane also asked, I might merge him and Phil Pollack asked a similar question about, like, what would be the threshold for an effort to evict the tenant? So Michael mentioned if the landlord said the tenant could have paid more rent, that they could be, liable for fines. Phil mentioned charging exorbitant fees and penalties in an effort to scare a tenant into vacating the property. So yeah, what point is that an effort to evict the tenant in your estimation?
Well, the first scenario where it's the landlord trying to challenge, say, how much the tenant's partial payment is or something. There is not really a lot of legal authority on this that we've been able to locate. We're still researching it. But generally, in a court case, the parties have the right to cross-examine the other side witnesses. And if somebody puts something in a declaration, I can afford to pay $600 a month. I can't afford to pay the whole $1,200. The opposing party would have the right to cross-examine that. But the problem is if you allow landlords to bring those kinds of challenges, you're really undermining the intent of the order, which is to keep people housed, to minimize in-person contacts, and really tenants should be able to take advantage of this protection just by providing the declaration, not having to show up to court and defend what they put in it and corroborate their statement and that sort of thing. So far, the one case that I found that seems the most analogous is there's the U.S. Supreme Court decided back in the 70s a case that dealt with search warrants, where if the police want to get a search warrant, they have an informant, that will provide a declaration to a judge, and the person whose property is going to be searched obviously isn't there. Otherwise, they would, know to go and remove whatever's, they have, if they had anything. And so the court looks at it and decides whether there's grounds, and then they can authorize a search warrant. And then later, if the criminal defendant winds up being arrested, they can say, hey, you never should have issued the search warrant because the affidavit that the informant provided was false. And so the Supreme Court had to figure out, how do you handle those situations? Because you may not have access, that person may not be around anymore, and it's kind of an impractical scenario. So the court came up with this standard where, in order to challenge the affidavit that leads to a search warrant, criminal defendant needs to show that there was some kind of fraud or bad, malicious intent on the part of the declarant. Not just that it wasn't right, but that there was, something really a mistaking place. So we kind of think that that's a sensible approach to these cases, where you just, you would take the tenant's word at face value, and so the landlord doesn't get a right to just come in and challenge it just because they think you can pay more. That they would have to actually have some real evidence to show that you made that declaration fraudulently, that you knew you could have paid more and you just lied, and they have to be able to prove that with some kind of evidence. Again, this is our analysis. This is what we think. It may ultimately be different from what a court says. Now, the second scenario about what about a landlord doing something like jacking up the rent in order to, I guess, get you to move out later. That's a good question. I tend to think that if you could show that the landlord, let's say that every year on November 1st, the landlord raises the rent by 5%. The landlord does that again. You're probably not going to be able to show that this was somehow motivated to get you to leave, because that's what they always do. But if every year the landlord raises the rent by 5%, and this year they raise it by 50%, well, come on. And then, if it's somewhere in the middle, then I think, if it went to court, there might be, court might have to take evidence to decide who's telling the truth, that sort of a thing. But yeah, I think a scenario like that could be, difficult to weed out.
So Kyle Lowry asked a question that I think you might have answered, but it was, if a writ was signed before September 4th, 2020 with the CDC order, can you file the affidavit with the court to quash the writ until January 1st, 2020? Have you seen courts rule this way if sought before or after September 4th? I believe you said yes, right?
Well, this is a tricky one. I mean, first of all, I would encourage anybody in that situation to at least sign the affidavit, give a copy to the landlord as soon as possible, file a copy with the court, send a copy to the sheriff. Because, if you don't do that, then you're definitely not going to stop the eviction. I think it may depend on how things are configured in a particular state. Normally, there's always something a landlord has to do to get a physical eviction to actually happen. So what the order does is it prohibits a landlord from taking any action to remove or cause the removal of a covered tenant. So if the landlord has to schedule the sheriff coming to do the physical eviction, if the landlord has to bring over laborers or movers to remove belongings, if the landlord has to do anything, then I would argue that that's a violation of the order because it prohibits any action. But if you're in a jurisdiction where the writ goes to the sheriff and the sheriff just executes it and doesn't even talk to the landlord, the landlord has no involvement in that process, then I think there's an argument that it's the landlord who's prohibited, not the sheriff. So that one, the tenant may be in a tough spot. But I have yet to actually see one of those play out. So I don't know.
Gotcha. We might have time for one more since we're at that hour. So Phil asked another question. In jurisdictions where there are no laws requiring just cause evictions, does your analysis indicate that the CDC would prohibit landlords from refusing to renew a tenant's lease? Does this fall into the CDC floor argument?
So if the landlord is declining to renew the lease, to me that's not a lease violation. That doesn't trigger one of the enumerated grounds where the landlord would have the right to pursue an eviction. Now I've heard people say, well, what if the lease itself actually says the tenant needs to move out at the end of the term and the tenant doesn't move out? Now, isn't that a lease violation? To which I say, perhaps, but you have to interpret regulatory language to avoid absurd results. And telling somebody you got to move out in order to comply with your lease and avoid being evicted would be an absurd result. So I don't think that type of situation would be an authorized ground to evict the tenant. I do think a landlord could lawfully refuse to say renew a 12-month lease for another 12 months. That okay, I'm not going to evict you, while there's this moratorium in effect, but I'm not going to renew for another 12 months, which would put you way past way past the expiration of the moratorium.
That actually answered another question. Somebody asked, I think that was more of a general question. Can a landlord not renew a lease when the lease is up?
Yeah, I don't think the landlord is required to renew a term lease. They just can't evict the tenant
right.
while during the moratorium period.
Okay. So for the sake of time, I think we might have to cut it short. But Eric, do you mind if I send? There's some more questions. Do you mind if I send them to you? No, is that okay?
Yeah, you can send them. I'll try to get to them as soon as I can.
Yeah, no, I understand you probably have a lot going on, but we'll do our best trying to answer everything. So really quick, I just wanted to remind everyone that Tenant Talk Live is now once a month. It'll be the first Monday of every month. So the next one will be on October 5th. So we'll send out the invite for that. And then also we have the print publication of Tenant Talk coming out soon. It should be out this month. Print should be by the end of this month, hopefully. That one will focus on our voter engagement efforts and ways that low-income tenants can mobilize voters in their communities and advocates as well. And yeah, so I think we'll cut it there. Thank you again, Eric. We really appreciate it. That was a great and informative presentation. And I think we'll see everyone next month. So thank you.
Thank you. Have a good night.
Yep.